On the record, the people of the state of Michigan versus Marteze Anderson, file number 24-02141. Council appearance.
Morning, Your Honor. Case Mark Hearing appearing on behalf of the people, appearing on first making a motion to practice under Michigan Court Rule number 8.120.
Motion granted.
Thank you, Your Honor. Good morning. Jared Austin appearing today on behalf of Mr. Anderson.
Okay, Mr. Anderson, you can hear us?
Yeah.
Okay, he's present from the youth center by Polycom. Today was the date set for probable cause conference. The matter scheduled for preliminary examination on the 23rd at 8:30 in person at the court. Are we continuing to examine?
Yes, Your Honor.
That is correct.
Okay, so there was bond of 25,000 cash surety, the curfew, GPS tether, and no contact order. So he'll appear in person next week for the exam. Do we need to address anything while we're on the record today?
Nothing from the people.
Not at this time, Your Honor.
Bond will continue. You're all set. You're all set, Mr. Anderson.
Date that preliminary exam, Your Honor.
August 23rd, 8:30. And on the record in the matter of the people of the state of Michigan versus Ronnie J. Williams, file number 24-02303, council appearance.
Morning, Your Honor. Case Mark Hearing appearing on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Williams. I'm in the courtroom. Mr. Williams joins us by the Polycom.
Your Honor.
You hear me, Mr. Williams?
Yes, Your Honor. Is there a chance I can speak with my lawyer before my court?
Okay, did you speak before today?
Yes.
No, I was never able to speak with her today.
Well, no, I said before today, not today. Because you can speak, you can speak with her when I finish dealing with the, I think there's a issue addressing bond today.
There was a question regarding bonds. Yes, Your Honor.
Okay, and then after that, then she can log on, but we're on the record now.
All right, Your Honor. My apologies.
Oh, no problem. So today was the date set for probable cause conference. There is a preliminary examination scheduled August 23rd, 8:30 in the morning in person at the court, and we're continuing to exam.
Yes, Your Honor. At this point, I've received some additional information from Mr. Williams that I want to follow up on. Yes.
Okay. Additional information that will impact the exam or?
Potentially. I only became aware of it this morning from him. It's not anything discovery related, just something I want to follow up on.
Okay, and what is the issue as to bond?
As to bond, right now, he is in custody on a 5,000 cash surety. I would ask the court to consider it for him for a lower bond. He's obviously not been able to make that bond. He has been in custody for some time now. I have received contact from an employer, PACOM, that is one of the individuals I want to follow up with. That is wanting to speak on his behalf, and I believe there's employment as well as he has other supervision. I don't believe he has a history of national report. I'd ask the court to consider him for a lower bond at this time.
People want to respond to the motion.
Yes, Your Honor. Made contact with the victim on this case. We have not specifically discussed any modifications or anything like that. So they've voiced any concerns necessarily about safety. At this point, I think it's the court's discretion. I believe Mr. Williams does have some circuit court issues going on though, and Judge on. He might be on probation.
He's currently on probation.
That was my understanding from APA McCray, that she remembered him from being in Aquilina on probation. I can't remember if that's done.
Okay, he was arraigned on August 8th by Magistrate Milmore, who set the bond at 5,000 cash surety. I have a bond report here. Bond report indicates some concerns. First, for the court, the concern is he's noted or listed as being homeless. Out employment. I recognize, I think the date of his arraignment, it said he had an interview that day. The other concern is his criminal history. There is a 2024 malicious destruction of personal property. It says that he's on probation for a 56A district court. It says that he is on probation for a 2024 weapons carrying concealed. It says that he has a 2023 aggravated domestic violence that he's on probation for at the circuit court. 2018 weapons, dangerous, carrying with unlawful intent. It says in this particular case, per the police report, that the police were dispatched to the Pennsylvania area in reference to a man with a weapon. And it says a victim stated he was almost stabbed by a man who had a drill with a drill bit. Then it was located and stated he was defending himself, so he grabbed a drill. As per his probation, he's unable to have a firearm or any weapon. He was placed under arrest. It also indicates here under risk factors that due to having a score of an average 4 violent felony offense, that it was recommended that he not be placed on a PR bond. The defendant has 2 or more convictions within the last 5 years, thus the defendant is not eligible for non-financial release due to a 765.6A. I think the bond is low compared to the history and the allegations that were made. So the bond motion is denied. Any additional matters for today's record?
Nothing further from the people. Thank you.
Just to make a record, Your Honor, I have had contact with Mr. Williams several times prior to today, and I will continue to do that. Thank you.
I think that was clear. I think he hadn't spoken to you today, and if you want to log in and speak to him now, I can have him put in a private meeting.
I will do that. Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus Colby Michael Mann, file number 24-02027. Council appearance.
Morning, Your Honor. Case work hearing on behalf of the people.
Your Honor, good morning. Jared Austin appearing today on behalf of Mr. Mann, who appears with us via Zoom.
Okay, Mr. Mann, can you unmute your device, please?
Yeah.
Is the date that was set for probable cause conference. And my understanding is that there's going to be a waiver to the circuit court. Is that correct?
Yes, Your Honor.
That is my understanding as well, Your Honor. Both parties would be waiving the circuit court, and there would be a pending offer to be placed on the record.
Council, you can place the offer on the record.
Yes, Your Honor. The offer extended on August 14th was to plead to count 1 embezzlement agent or trustee from $1,000 to $20,000. That's a 5-year with restitution reserved. In exchange, we will dismiss the have forth notice. And we're just working out the exact amount of restitution.
Complete and accurate as the offer.
That is correct, Your Honor, and we will continue negotiations at circuit court.
Okay, and Mr. Colby, you want to waive your right to a preliminary examination?
Yes, ma'am.
You understand the purpose of the preliminary examination?
Yes.
You have the right to require the prosecution put forth evidence at your preliminary examination that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes.
And it's your wish to unconditionally waive your examination?
Yes, ma'am.
Okay. No one's threatening you to do that?
No.
Has there been any promises that you are using to entice you to waive your exam?
No.
Okay, your bind over date is gonna be August 28th. You do not need to appear in the circuit court on that date. That's the date that they're gonna get the file from the district court. Okay,
Okay.
your next court date is going to be a pretrial. Your attorney will be made aware of that.
Okay.
Do you have any questions so far?
No.
Are you still at the address on Clyde Street?
Yes, ma'am.
Okay, your phone number still ends in 2367.
Yes.
If your address change, it's your responsibility to notify the court so you don't miss any of your court dates. Bond was set at 2,000 personal recognizance, and that will continue. Any additional matters for the record?
Nothing further for the people. Thank you.
Nothing additional on behalf of Mr. Mann, Your Honor. Thank you.
Thank you. You're all set, Mr. Mann.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Dominique Blackman, file number 24-01564. Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Dwayne Silver from the Office of Public Defender on behalf of Dominique LaShawn Blackman, who is standing at the council table to my right.
Okay, good morning. Today was the date scheduled for a probable cause conference, and my understanding is there's going to be a plea.
Yes, Your Honor.
Okay,
You want me to approach Your Honor with the
Yes,
plea
please.
sheet?
okay. Since the people are offering for the defendant to plead to an amended count 3 of attempted interfering with electronic communication under MCL 750.5405A. It's a misdemeanor. Maximum penalty is 1 year and or $500 in fines. And to plead to count 5 of domestic violence, 93-day misdemeanor. The remaining balance and the habitual second notice will be dismissed. It's a killer brew. It doesn't say what the killer brew is.
I apologize. No, to no upfront jail.
Okay.
I apologize.
Killer brew to no upfront jail. That's complete and accurate.
It is accurate, Your Honor.
You want to accept that offer, sir? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes.
Okay, I have an advice of rights and plea information sheet. You can put your hand down, sir. Did you sign this?
Yes.
Did you go over this with your attorney?
Yes.
You understand all the rights listed there?
Yes.
And you want to give up those rights?
Yes.
So you have the right to the presumption of innocence. That means you're innocent until proven guilty. You have the right to require that the prosecution prove your guilt, and they would have to prove each element of the charges brought against you beyond a reasonable doubt at a jury trial. You have the right to remain silent at that trial and not have silence be used against you, or you can waive your silence and testify at the trial if you like. You have the right to confront and cross-examine in court any of the witnesses that they intend to call to testify against you. You have the right to subpoena witnesses to testify on your behalf or present evidence at your trial that you believe show a defense to the charges being brought against you. So you want to give up all of those rights.
Yeah.
Anybody promising you anything to get you to waive your rights and enter a guilty plea?
No.
Right, threatening you to get you to enter a guilty plea. Are you currently on probation or parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your employer. It could also result in a conviction that may have impact on where you can travel or immigration status that you might be seeking. As to count 3 of attempted interfering with electronic communications, how do you plead? And as to count 5 domestic violence, how do you plead? And are you pleading guilty because you believe you're guilty?
Yes.
That's always the one that gets it. thing. Factual basis.
That's right. Mr. Blackman, I'm gonna take you back to March 18th of this year, 2024. Were you at the location of North Butler and Ionia Street? Yes. Do you agree that's in the city of Lansing? Yes. County of Bingham? Yes. State of Michigan? Yes. At that location, were you there with the Carissa Heiner? Yes. Carissa Heiner was your then girlfriend, is that correct? Yes. So you had a domestic relationship, correct? Yes. And at that point, she broke up with you and you were arguing, correct? Yes. And during the course of the argument, you pushed her violently hard and took her phone away, is that correct? Yes. And that push was an offensive touching of her, wasn't it? Yes. Okay, and the reason that you took her phone was she was threatening to call the police, correct? Yes. And she eventually got her phone back, but that was after a significant passage of time, is that correct? And it was that she recovered it, wasn't that you gave it back to her, correct? Yes. Your Honor, I think I elicited the factual basis.
Any questions from the prosecution?
Just one, Your Honor. Mr. Blackman, the pushing was not done out of self-defense, was it?
What?
The pushing.
No.
Thank you, Your Honor. People are satisfied with the factual basis.
Yeah. The court is also satisfied with the factual basis. I will accept your plea and I find it to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing October 4th at 9 o'clock in the morning. When you leave here, you go down one floor to the 5th floor. You're going to check in with the probation department so they can get you scheduled for a pre-sentence interview, okay? Okay. Let's see. You can appear for your sentencing via Zoom. Any questions at this time, sir? From the record counsel.
No further from the people. Thank you.
Nothing further from the defendant. Thank you, Your Honor.
Thank you. Yes, sir.
Good evening, Your Honor.
Same to you. And then Mr. Alexander is in custody. Are we running an exam on that one?
I'm unsure at this time, Your Honor. I do have an officer here present on.
Let's see.
I know the court has adjourned it a few times already because our named victim, Kathy Curley, has been in rehab. I just got noticed that she is still in rehab and is going to be there for a year. So I was going to request an adjournment for good cause again, but I know.
For a year?
Not for a year, Your Honor. It's, she continues to tell us she can appear via Zoom, but I know Your Honor's policy about that. I'm very
It's not really my policy. I think that's law.
Yeah.
They would have to, and the defense would have to waive their appearance in person.
Yes, sir.
I don't really care. In person. So let's see,
I do have an officer here and I'm ready to proceed without her.
we will have Alexander brought up. On the record in the matter of the people of the state of Michigan versus Jalen Carter, file number 24-01031, counsel appearance.
Morning, Your Honor. Case Mark Hearing is hearing on behalf of the people.
Tells me that Ms. Donnelly is representing Jalen Carter.
Yes, I don't know where he is. I'm gonna check him out one more time. Sorry, Assistant Public Defender Sherry, I am the defendant exam.
Okay, have you had any contact with him recently?
Your Honor, I've tried calling him, texting, emailing, no reply.
Oh, okay, he didn't get his PSI then.
No.
So
He
we'll
didn't.
show bench warrant. On that. Okay, on the record in the matter of the people of the state of Michigan versus Jacob Garcia, file number 23-02900, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Jacob Garcia, who's to my right.
Today is scheduled for a preliminary examination for domestic violence third. Are we running an exam today?
Your Honor, we have attempted contact several times at our office with the necessary witness on this, Ms. Rosemary Arnold. We have been unsuccessful in even making contact with her. I checked the hall this morning. I haven't seen her, and I haven't heard from court security or anyone else that she's here, so we've been able to proceed.
Counsel.
Your Honor, with that, we would ask the court dismiss it without prejudice.
The motion to dismiss without prejudice is granted. The people do have the right to reissue the charge against you within the statutory time frame. Okay? Do you have any questions about that?
No.
Okay, we'll get you a copy of the dismissal in just a moment. I'm not sure why that is. What's going on here? Oh, boy. Representing Mr. Howard or Miss Howard.
Hi,
Is she present?
she is not. I have an explanation for the court on that.
I haven't seen, it looks like I got an email. here. On the record in the matter of the people of the state of Michigan versus Stephanie Howard, file number 23-03163, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
And Luke Goodish from the Public Defender's Office here to represent Ms. Howard, who is unable to attend today. Reason for that, Your Honor, it's my understanding that Lee Scott is here from he's a paid program director of Love Thy Neighbor Ministry. She's been working with them. He was driving her to court this morning. Apparently she had some type of allergic breakdown, or I'm sorry, allergic reaction. And he took her to Sparrow Hospital emergency room where she currently is at. Based on that, Your Honor, I would ask the court to reschedule this matter at the time. He is here to verify that if the court needs any further verification regarding that.
You said his name is
Lee Scott.
That's who the email is that I received is from. Lee Scott, is that you, sir?
Yes.
What's your relation to Miss Howard?
I work with the program at Love Our Neighbor Ministry here.
You work with her how?
She's what we call the house den mother, but we feed the homeless and help the needy around the community. She's the live-in person in the home that takes care of us. I live outside.
Okay, and so
Yeah, I believe she was in inpatient rehab or residential rehab,
Yeah.
and then when she got out of that, she transitioned to this program.
what time did you drop her off at the hospital?
I was on I want to say approximately about 8:45, somewhere around there, or 10 to 9. I was on the transportation she had to get here.
So she did what?
I was the only transportation she had.
Okay, and what was the allergic reaction?
She started having the swelling in the face. I'm not really sure what it was. It's called I took the Sparrow emergency room.
Okay, so you sent me an email just before you did that?
Yeah, I had intended to send you an email yesterday, but I just sent it out this morning.
She didn't have any swelling when you sent this email?
I was not there at the time of I was in the driveway. I was not in the house itself.
Have you spoken to your client today?
I have not, Your Honor.
Okay, I'm gonna hold the bench warrant to the end of the day. Because if it's an allergic reaction, she can go to the doctor and see what's going on, and then she can get here for her sentencing. She could have even appeared virtually, but she's gonna make contact with you today. Otherwise, I gotta issue a bench warrant.
We'll try to get in contact with the court today, okay? Thank you.
All set for that. Who was this before? This was for Garcia. On the record in the matter of the people of the state of Michigan versus Justin Peace, file number 24-01030.
Morning, Your Honor. Case Markarian, appearing on behalf of the people.
And good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Justin Pease, the gentleman who's standing to my right.
You can grab it. Okay, let's see. Today's the date set for sentencing. I do have a pre-sentence report. It was prepared on the 9th of August. Did you get a copy of that, counsel?
I did.
It's easy to make corrections, updates, or deletions.
No.
You can make allocation.
Thank you, Your Honor. I'm asking that the court follow the recommendation to sentence Mr. Pease to a term of probation. Certainly, I guess I'll just get right out in front of it. Certainly, Mr. Pease has some criminal history. There's no getting around that. And I recognize that the probation agent has some limited concerns regarding his prior criminal history. However, with that said, I think that the probation agent points out some very good things for Mr. Pease, and I highlight particularly on the very first paragraph of this section, the overall impression section. It says, it should be noted that the defendant was very open and honest regarding this offense and his past substance abuse history. Additionally, while awaiting his sentencing date, the defendant has been in constant communication with this officer regarding his bond conditions and his bond testing. I think Mr. Pease has demonstrated that he is very motivated to get this changed. I've had a number of conversations with Mr. Pease in which he talked about substance abuse had previously controlled his life and impacted him in all sorts of ways. I think he's finally at that point in his life where he's recognizing that he doesn't want to continue being that person. He wants to move forward. I think he's taken, and as detailed in the PSI, I think he's taken significant steps. He's got a full-time job now. He is enrolled in multiple programs at CMH, which is essentially what the PSI is recommending anyway. He's enrolled in a program called Healthy Living. He's also enrolled in a once-weekly therapy with a counselor. He's involved in a peer recovery group. All of those are through CMH. He is in the process, has been screened for, and is on a waiting list for a psychiatrist through CMH. The hope is that the psychiatrist may be able to shed further insight into some of the mental health struggles that Mr. Pease suffers from and that are detailed in his PSI. I certainly think Mr. Pease has shown the court. He's always, the other thing I guess I would say is he's always shown up for court. He's always been here. He's always taken responsibility. He's been in constant contact with the probation agent. I think Mr. Pease has done enough to demonstrate that he's worthy of at least an opportunity for probation. I also, I guess, want to just point out, Your Honor, we were here a couple of weeks ago for an alleged bond violation. I know that the court was concerned about the fact that he was doing oral swabs at that time, and the court ordered him to immediately provide a urinalysis test. And as reflected in that PSI, he immediately went, he did that urinalysis test. That test was negative, and I'm not aware of any other bond violations he's had since that time. I submit to the court that this is a very motivated individual. He certainly wants to change, and I'd ask the court to give him that opportunity.
Thank you. I noted that at the end of the report that we've not had any issues since your analysis has come back negative. So I'm glad to see that. I don't know if he wished to make his own statement.
I'm glad that I can provide the truth that I'm actually trying to change. You know, I know you gave me alternate route was either provide your. I mean, yeah, and it's hard, but if you keep me out of jail, and that's what it takes, that's what it's gonna take. And I'm okay with the struggle. You know, I'm proud to be sober. I'm proud to get my life back together. I'm doing everything I can. Like I picked up that peer recovery group, decided to, choices I wanted. I'm tired of looking over my shoulder. I'm tired of living like a drug addict. I don't want to be it anymore.
That's very positive and it's encouraging to hear. You're looking better each time I see you, and that's important. That shows your progress. And so you don't look like the same person I saw the first time. That's a fact. And I think your attorney would even agree with that. And so that means you're on the right track. And it wasn't just about you testing or going to jail. The issue was that we couldn't get an accurate reading with the swab testing, and we wanted to ensure that you were going where you needed to go. And so I'm happy to hear that you're doing that you're engaging in programming it, and that you've turned over a leaf is what appears to the court. And so even though you weren't successful with probation previously, you're not there
Can I address
anymore.
that?
Yes, you absolutely can.
So it says that the time before, that they revoked my probation. I actually successfully completed that because I had a violation. They couldn't word it that way. I got off on the 19th, but the judge told me in person, he told me that I can't successfully complete you because I had a bond violation or something that was never addressed. It somehow got lost from Oakland County to here. But I did successfully complete it last time. They just said they couldn't word it that way because it was bond violation. I'm not sure exactly how that went.
I'm not sure how that goes either, to be honest with you.
But
That's I can speak to it. I can only say what it states here.
right.
And if they have a bond violation that they didn't address, if it were me, if it was never addressed, then I would probably have withdrawn the violation. They don't have to keep the violation there unless it's sustained. Nonetheless,
I'm not sure.
hopefully, the trajectory you're on now, we won't even have any bond violations that will go unaddressed. We won't have those issues because you're doing what you need to be doing. You're working, you're engaging in your treatment. You're getting screened and you're on the wait list for additional resources. So you're in an excellent place and I want you to stay on that so that we don't have any issues with you while on probation. So I've reviewed the report. I think the recommendation is appropriate, so I will adopt it. It's for 9 months probation. While on probation, you have the following conditions. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You'll continue to submit to random preliminary breath testing and urinalysis testing. You are responsible for the cost of that, okay, sir?
Yes.
You should not be at any bars or nightclubs while you're on probation. You're not allowed to purchase or possess a firearm or ammunition or weapon of any kind. You're not to engage in any assaultive or threatening behavior. I'm going to order that you continue your programming through community mental health. And attend a 12-step program. You're also required to maintain your employment and provide verification of that to your probation officer, okay?
Okay.
Got any questions so far?
No.
You will report via Zoom for probation.
I go downstairs after this, right? And
Yeah, you'll
set up.
check in person today, but your monthly reporting will be via Zoom, okay?
Okay.
Unless you want to come in person, you have that option, but.
No,
Okay. Fines and costs. There's a $30 per month oversight fee that you're responsible for while on probation. There's a $75 crime victim rights fee that must be assessed plus a $50 state minimum cost. Gonna waive discretionary fines and costs. Probation oversight fees, if you do 9 months, would be $270 plus the statutory fees. It comes out to $395, and you would be able to make monthly payments on that, okay?
I have 100 to put on that today.
Okay, sounds good. We'll allow you to do that. I'm gonna advise you also of your advice and rights as to probation. So you've been placed on a term of probation in the 54A District Court and your conditions are individually tailored and are specific to address your individual needs. Except for domestic violence, criminal sex crime, stalking, or an offense where the defense of guilty but mentally ill was asserted, you are eligible or may be eligible for early discharge from probation. I've ordered you to 9 months. Once you've completed half of that, 4.5 months, if you do not violate it in the 3 months before that, and you've been compliant with all of your programming requirements, including completing or attending 12-step program, you can make a request for early discharge from probation. If you wanted to do that, you would do so by using the court's MC 512 form, which is on the court website, or you can get it from your probation officer. You would file a copy of that with the court and then also serve a copy on the prosecutor's office. Prosecutor's office would have 14 days to file any written objection to your early discharge from probation. If it's set for a hearing for some reason, you do have the right to hire an attorney to represent you. You do not have a right to court-appointed counsel for any hearing for early discharge. I have never held a hearing for early discharge, just so you know. I usually just review it off the record. And so your probation officer can make that request for you without you having to do it as well, if they believe you're eligible for early discharge. Do you have any questions about that?
No.
And so again, you'll check in downstairs with probation once you leave, so they can get to review this order and make sure they have an accurate contact information for you. And then you'll be on your way for the day. Problem, and good luck to you. If all goes well, I won't see you on this side.
I think this is the last time we'll be standing in front of any judge.
Well, you never know. We do weddings too.
Maybe.
Have a good one.
Thank you, Judge.
Thank you, Your Honor.
You're welcome.
Sorry about that. Yeah. Well, I was looking for a spot for me to sign. I was like, what did I get those for?
That was
Thank
Mr.
you.
Pease. Ms. Donnelly's not here right now. Is Edisbell Reina Guerra here? No. What's your name, sir? Okay, Mr. Shaw's here. Are you ready on Shaw?
I am, yes.
Okay, when he comes back, we'll call that. For the record, in the matter of the people of the state of Michigan versus Matthew James Shaw, file numbers 24-01459, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Mr. Shaw. He stands present to my right.
Mr. Shaw. A preliminary examination, but then I also see a bond violation. Let's see. If I'm not guilty, for magistrate memo on that. Okay, so there's a plea sheet here. The plea offers to the defendant a added count 4 of aggravated domestic violence under Michigan Compiled Law 750.81A2, which is a misdemeanor, 1 year and or $1,000 in fines. There is no objection to sentencing under 769.4A. The people will dismiss count 1, 2 is 1, 2, and 3, but we're actually just gonna amend count 3 to aggravated. So the people would dismiss count 1 and 2, correct?
Correct, Your Honor.
Okay. It says that we will also dismiss the PA 53 violation, but that's a contempt of court order. So I have to dismiss it.
Yes, sir. It's a part of the agreement that we wouldn't proceed on it.
I don't know if I'm in agreement with that,
Yes,
but that's your offer,
yes, sir.
and you want to accept that offer?
Yes, sir.
Okay.
And if I may, Your Honor, was there a mention for the sentencing agreement as well? I don't know if I heard the court say that.
Deliveroo, no upfront jail.
Yes.
And not, no objection to 769.4A. Okay. And what's I apologize, this phone, I had to go get it because they have the security thing that makes us click our phone to get into our computer. Which is weird, but nonetheless. Let's see. And the allegation of the bond violation was contact, not necessarily violent contact, correct?
That was my understanding from reading the report, Your Honor. There was alleged to have been contact, but there was no allegations that there was anything violent, assaultive, or intimidating in nature.
Okay, raise your right hand. Yep, that one. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury? Okay, and you heard the plea offer, which is for you to plead guilty to amended count 3 of aggravated domestic violence and no objection to special status of sentencing number 769.4A. That the people are recommending dismissal of the PA 53 and that there's a killable of no upfront jail. Correct? And you want to take that offer?
Yes, Your Honor.
And that's your signature?
Yes, Your Honor.
Did you read this with your attorney?
Yes, Your Honor.
You understand all the rights there?
I do.
And you want to give all of these rights up?
Yes, Your Honor.
Okay. That means you're going to give up your right to the presumption of innocence. You're innocent until proven guilty. You understand that?
Yes, Your Honor.
You have the right to require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any other witnesses the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe show a defense to the charges being brought against you. You have the right to remain silent and not have silence be used against you, or you can waive your silence and testify for yourself if you like at trial. You understand all of those rights that you would be giving up?
Yes, Your Honor.
Is anybody threatening you to get you to give those rights up?
No, Your Honor.
Are you sure? I saw you tearing up in the back. Did he threaten you at all?
No, Your Honor.
Okay. Any promises being made to you
No,
to
Your
get you to plead guilty?
No,
Are you currently on probation?
no, Your Honor.
Are you on parole?
No, Your Honor.
You understand that if you plead guilty, it can have an impact on travel or immigration status that you may seek. So you might not be able to go out the country to certain places. You understand that?
Yes, Your Honor.
It also could be a conviction that you may need to report to your current employer.
Yes, Your Honor.
You understand that?
Yes, Your Honor.
Okay, and I recognize you're seeking the special status, but you haven't been given that yet. I'm gonna also advise you of the Killer Brew agreement. That's an agreement between you and the prosecutor. I'm not a party to that. So if at the time of your sentencing, I decide that I am going to sentence you to upfront jail, I would give you the opportunity to withdraw your plea at that time, okay? As to the amended count 3 of aggravated domestic violence, how do you plead?
Yes, Your Honor.
On a factual basis.
Yes, Your Honor, thank you. And I think Mr. Shaw will be eliciting the factual basis for the dismissed count 2, so the court can accept that for the aggravated domestic violence. Mr. Shaw, taking you back to May the 13th of this year, 2024, were you at or near the location of 4726 Duvernay Drive in Lansing, Michigan?
Yes, sir.
Is that here in Ingham County?
Yes, sir, it is.
That daytime and location, did you have contact with Camille Weiss?
Yes, sir.
And is that someone that you have children in common with?
Yes, that's my wife, 12 years of.
And at that daytime and location, there came a point where between you and Ms. Weiss, you became angry. Is that correct?
Yes, sir.
And out of anger, you threw a hard bottle in her direction. Is that correct?
Yes, sir. I threw a water bottle.
Okay. And you were angry at the time, and that was something intentionally that you did. Is that correct?
Yes, sir.
Okay. And that would have put someone like Ms. Weiss in fear that she may have been struck with that bottle. Is that correct?
Yes, sir.
Okay. And as a matter of fact, that bottle ended up hitting the wall and bouncing off and striking her in the face. Is that correct?
Yes, sir.
Satisfactory, Your Honor.
Any questions from the prosecution?
Just one, Your Honor. Mr. Shaw, that was a metal water bottle, correct?
I think it's not metal. It was like a hard plastic. It's a Yeti, but it wasn't.
It's like something like this?
Yeah, but not the metal kind. It's
Oh.
like a composite. Or something. Probably equally as hard as metal, I'm sure, or harder.
People are satisfied with the factual basis, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea and I find your plea to be made freely, voluntarily, and intelligently. I will dismiss the bond violation. And matter is scheduled for sentencing October 4th at 9 a.m. You did get a copy of your notice to appear already? Okay, when you leave here, you're gonna go down one floor to the 5th floor. You're gonna check in with the probation department so they can get you set up for a pre-sentence interview. So they can provide me with the report and a recommendation as to how you are to be sentenced, and also a report about your domestic abuse status. Did you have a question for the court, sir?
Yeah, can I ask my attorney real quick?
I'm sorry?
Can I talk
Yes,
to my attorney?
absolutely.
No, ma'am, sorry, I don't.
Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
Yeah. there's a few matters on bond, if I may address the court on, Your Honor.
Yes.
Thank you, Your Honor. While Mr. Shaw has been on bond, there's been several out-of-state travel requests that he has made for work. And pretrial services has asked me to reach out to the court on this issue. I think maybe initially we thought that that might be more of an isolated thing, but Mr. Shaw does have numerous opportunities that comes up for work for out-of-state travel. The issue is that most of the time, these opportunities present themselves on a very short notice, and it's become quite cumbersome upon pretrial services with their workload on sometimes a day or two or even less notice to formulate the necessary request to the court. And also, it doesn't always necessarily give adequate amount of time for the court to review those travel requests for Mr. Shaw. So I would ask if the court would consider just amending Mr. Shaw's bond that he is permitted to travel out of state for work purposes, provided that he can provide the necessary documentation or verification to the court of pretrial services that he needs.
All right, only see one request since he's been on bond.
I think there's been at least 3, Your Honor. The court wasn't always here. I know Judge Ward filled in your stead, but there have definitely been multiple requests.
Oh, I think both of them were signed by Judge Ward, that's why. It was like she did one on June 10th. And then another one on July 26th. However, he's now pled guilty to a misdemeanor and will be reporting to the probation department. So we just need to know. I don't have a problem with a blanket approval for out-of-state travel for work purposes. He just needs to provide that information to our probation department.
So in other words, is the court amending his bond to reflect that? He just needs to notify the probation department of when and if that occurs?
Correct.
Okay.
He's on tether, is that correct?
He is currently on tether.
Are we requesting the tether be removed?
If I could ask the court to consider that as well, Your Honor. He does not have any tether violations that I'm aware of.
Your Honor, I have no objection. I'll leave it to the court's discretion. I obviously don't want to interfere with someone's work schedule.
Well, we were talking about tether now.
And as for the tether, Your Honor, I attempted to contact Ms. Weiss yesterday. I didn't hear back from her specifically, but I do have case notes in the file from Ms. Petrosky reflecting, and our victim advocates reflecting that she's not even in the city of Lansing anymore. She's moved. She's still in the state. She's in Midland now, but she's not in the city of Lansing. I was just trying to get a new address and didn't hear back.
Oh.
But we had no objection to that either, based on the notes that I saw.
Okay, so I'll amend the bond to allow the defendant to travel for work with a blanket travel allotment. He just needs to provide the dates and location to probation. And when you go down to check in, you can probably get an email whereby you can send that request or that information so that they know when you're going to be traveling for work. You can have your GPS tether removed. The no contact order will remain in place, however, so you're not to have contact directly or indirectly, nor are you to be wherever Ms. Weiss is, okay?
Yes, Ron, I have a question.
Yep, I'm here to answer.
Me and I were talking about this, but so we have mutual children. Is there any way that I have been literally doing everything to not have any contact whatsoever in any way, shape, or form?
And
my mother.
And I think, and I think what Mr. Shaw is saying, Your Honor, I don't know if the arraigning magistrate was aware at the time they had children in common. I don't know, and I don't know if the bond, if there's any provision that allows for any type of limited or third-party contact. And I think what Mr. Shaw is asking, if the court would at least permit some type of third-party contact as it relates to their children in
How old are your
common.
children?
We have 3 children.
How old?
I have a 13-year-old, an 8-year-old, and a 4-year-old. Almost 5.
Okay, and so your mother would be the third party contact?
Yes, Your Honor, that would be accepted. Just for like pickups and drop-offs and things like that.
Third party contact for child care is allowed. Any additional matters?
Nothing further for the people. Thank you.
And just one other clarification, Your Honor, I think sounds like it's already been resolved, but I just want to make sure, it sounds like the people have confirmed that Ms. Weiss is no longer living here in Lansing. She's not living at the address of the offense date. I know in a previous email strand, the court stated that it would allow Mr. Weiss to go back to that residence that Mr.
I
Shaw,
amended his bond on the 23rd.
provided that she's not there.
That he could return to that house on July 23rd. I amended his bond for that.
I just wanted to make sure, and it sounds like Ms. Weiss is no longer there in any area, so that.
That's what I was told, but then it looks like I got that bond violation shortly thereafter, so I'm still relying on the information that I was provided. She does not.
She didn't know that I'd be there yet, I guess, and I went to the house and I was there for 2 days and she knocked on the door. And I was like, you gotta go.
And the only part that I was asking for clarification on, because I know Ms. Polda had followed up in an email strand on that, saying that she had had some contact with Ms. Weiss indicating she may return there at some point when the school session starts.
No, I don't know how that works. He's in the house now. She can't go.
That's
He can't
perfectly
let,
fine.
yeah, we're not doing all that.
I appreciate that, Judge. That's all I wanted clarification on, so I think that covers all the issues I needed to address. I appreciate the support.
No problem. Any additional matters?
Nothing further from the people. Thank you.
Yep, I said he can remove his tether.
Yeah.
Thank you.
You're welcome. Is that Mr. Alexander?
Yes.
Okay, just real quickly, have we seen, is it Raina Guerra?
I don't have any contact with him either, Your Honor.
I
can't, well,
His stats aren't that great today.
no, well, he, and Vining's down, so I can't tell because I know that he is mentioned.
Said he's where? You said he's where now?
I can't check if he's in custody because
Oh, got it.
But he did have, the pre-sentencing report listed a few warrants he had. I did double check. He did fail to appear for a probable cause conference last, on the end of July. I tried to leave a message with him. I have no contact.
Okay, we'll bring forward him. Let's see. Does anybody see Mr. Johnson?
No, Your
Green
Honor.
Johnson? No, I'm not.
I emailed him yesterday afternoon.
Did
inquiring
he ever
about-
come yesterday?
I heard rumors, but I won't say.
Okay. I heard that he did not, so we'll go ahead and make sure his client, Maddie Horton's not here, I'm assuming.
Not that I've seen.
Okay, well, we'll deal with that. Okay, so that leaves me with one file. And something else. One more file for the morning, and that's Alexander, and we are running an exam, correct?
Your Honor, we're asking prosecutor and I for another adjournment.
Okay, on the record in the matter of the people of the state of Michigan versus Patrick Alexander 24-00681 FT. Here.
Morning, Your Honor, case Mark Aaron, appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Patrick Alexander, who is present to my right.
Okay, Mr. Alexander, we were supposed to have an exam today. Let's see, and I understand that there is an issue with the complaining witness presence at this time as well. So what is the request for an adjournment for? Is it for that or something else?
It's a little bit of a combination, although, Your Honor, I believe we're ready to proceed, and I honestly don't see any reason pursuant to MRE 11018 why we would even need the complaining witnesses here. Any testimony they would provide would be for value, ownership, or possession of the property, and there is an exception to hearsay use officers for on that. So I was ready to proceed, but I've been provided information that perhaps there is some more investigation to be done and some more information to be provided about the defendant's ability to lawfully use the vehicle at this time. I'm not objecting to an adjournment on that.
How much time are you looking for?
Your Honor, I don't believe it will need much time. Enough for Mr. Alexander has things he needs to deal with in Lenawee. Our hope is that he is going to be accepting a misdemeanor offer on Monday and be released on parole. I need to get with him as well as another witness that is also in custody. But Your Honor, I don't need much time for that. I also want to have an opportunity to see if the prosecutor can, because they assure me that that she is on board, and I would like the opportunity to have a cross-examination, not base it on hearsay.
I don't know when she's coming out of rehab, so I can't speak to whether or not she'll be here, but I know our next available date is in October at this point.
Okay.
October 18th. October 18th at 8:30. You have any questions for the court today, sir?
Oh, ma'am, I'll try to be on time for the next one. Sorry.
Well, I don't think this was within your control. I thought
Well,
you were ready to
no,
go.
but I'm here now. I apologize.
Very good.
On behalf of everybody. Yeah.
Okay, sounds good. Any additional matters for today's record?
Nothing further from the people. Thank you.
Not for defense, thank you.
You're all set.
Have a good day.
Same to you.